Hello, welcome to Illinois Law, sponsored by the Illinois Bar Association. My name is Sam Kavathis, and I'll be your host for tonight's show. We have a great topic on mortgage foreclosures, the litigation process. And I have three fine guests to help us with tonight's discussion. My first guest is the Honorable Margaret Brennan. Judge Brennan has served as a judge in the Circuit Court of Cook County since her induction to the bench in December of 2002. As a judge, she has served in the 1st Municipal District, the 5th Municipal District, and presently is assigned to the Chancery Division Mortgage Foreclosure Mechanic Lien Section. Prior to the bench, she practiced law for 15 years, working for the City of Chicago, Commonwealth Edison, and Exelon Corporation. She is a graduate of the University of Illinois and obtained her law degree from IIT Chicago-Kent College of Law. Judge, welcome to tonight's show.
Good evening.
My second guest is Steve Bashaw. Steve is principal of the firm of Stephen B. Bashaw, P.C. with offices in Lisle, Illinois, and his practice concentrate in real estate litigation, mortgage foreclosures, having represented financial institutions and defending debtors. Steve is past chair of the Illinois State Bar Association Real Estate Section Council, chair of the Case Law Committee, a member of the Illinois State Bar Association Assembly, and director of the Illinois Real Estate Lawyers Association. He is a frequent continuing legal education speaker on case law updates, mortgage foreclosures, and real estate law for the Illinois Institute for Continuing Legal Education, the Illinois State Bar Association, and all the other bar associations in the Chicagoland area. Steve is author of articles, and he has contributed to the Illinois Mortgage Foreclosure Practice Handbook, Nuts and Bolts of Foreclosure, and Mortgagers in Distress, representing defendants in foreclosures. In 2009, Steve was honored as a recipient of the Edward J. Lewis II Pro Bono Service Award from the Chicago Bar Foundation and Chicago Bar Association in recognition of his work in assisting and training volunteer lawyers in mortgage foreclosure defense for various legal assistance providers. Steve, welcome to tonight's show.
Thank you.
And my third guest is Mitch Lieberman. He is a partner in the law firm of Noonan and Lieberman Limited, which is located in Chicago. He was admitted to practice in Illinois in 1986 and has concentrated his practices in commercial and residential mortgage foreclosures, real estate, and mortgage litigation, creditors' rights in bankruptcy, and civil and appellate practice. He received his BA degree from Indiana University and his law degree from DePaul University. In addition, throughout his years of practice, he has been appointed by the Cook County judges to represent their court-appointed receivers regarding commercial foreclosures, including condominium projects, high-rises, and multi-unit office buildings. He is a co-author of Illinois Mortgage Practice, ICLES 2003, and also a co-author of the Real Estate Litigation Practice for ICLES. He is a faculty member of the Illinois Business Institute and Lorman Educational Services. Currently, he is a member of the Chancery Division Mortgage Foreclosure Case Management Advisory Committee and has been appointed the chair of the Cook County Commercial Foreclosure Committee. Mitch, welcome to tonight's show.
Thank you, Sam.
Why don't we start out by telling our listeners what actually happens in a default, when you are in default for a mortgage?
Well, I think we have to go back a little bit to the landscape and the process. Default would be a borrower fails to make a monetary payment to the lender pursuant to a contract. Mortgage and note is a contract. There are certain notices that have to be provided by the lender, and once that is done, if a borrower cannot work it out prior to litigation, a lender will file a mortgage foreclosure suit. Again, I think conceptually everyone has to understand that a lender is owed money and it is secured by a piece of real estate. In Illinois, in Cook County, a summons is issued to a borrower. Once it is served upon the borrower, it's very important that the consumer and the borrower understands what their rights are.
What do you say served? What does that mean? You know, lawyers know what the term means. What does the person mean when they're served?
That means a third party will come to their home and give them the complaint and a summons. The summons basically will tell them what they can and cannot do and tells them when they need to appear in court to file an answer. In Cook County, the summons has changed. They're bilingual. They're in English and Spanish. And it is very important at that stage that the consumer or the borrower either attempts to get counsel. They must be part of the process, because once they're served, they have certain rights, and a lender has certain rights. They have 7 months from the date that they are served to pay back the entire amount of the mortgage. That's called redemption. Also under Illinois law, there's something called reinstatement. From the date they're served, they have 90 days to cure the arrears or just pay back what they owe. So it's very important at that stage. Generally, the process would be in Cook County, a lender has to wait 60 days after that service before they can even come to court. Once service is done and the 60 days is over, a lender will move for a default judgment. And at that point in time, if a judgment of foreclosure is entered, it is the greater of the 7 months from the date they were served or 3 months after that judgment date before they can lose their home. It's
so they
very important.
better do something. Steve, when clients come to you with these mortgage foreclosure papers, what are some of the steps that you'll tell them that they'll do?
Well, the first thing we talk about is a lot of times people come in, Sam, and they say, oh, well, I'm talking to my lender about modifying my loan, because they're already in the process, thank goodness. And so I don't have to appear in court. And that's a mistake. Even though you're talking to the lender, right, that's, with this hand, and the litigation can go forward. So it's very important, even as a pro se, as a person who's representing themselves, to take your summons, go down to the courthouse, it's the 8th floor in the Daly Center, and file an appearance so that you can appear before the judge and not make the mistake to think that, well, I'm talking to the lender about modification so I don't have to talk to the judge. You know, you have to keep both things going at the same time.
So once that happens, Judge, what happens when they get to court? How do they get to court?
Well, they can come to court either on a case management date, which is set by the clerk's office, or in response to a motion for default, which is how I typically will see most of my the self-represented individuals. And at that point in time, I'll advise them about the mediation program that's in place in Cook County for homeowners.
And what is it? Tell the listeners about the mediation program, because it's a great program that's offered by Cook County.
It is, and it's a program that's for homeowners, not for investment or people who have chosen to move out of their property who reside in Cook County. It is a means for them to meet with a housing counselor to evaluate what is their best solution for resolving the situation, whether they want to go with a modification, whether they want to try and work out a different alternative solution with the bank, and then to see whether or not they would be best served by a mediation program which can bring both the borrower and the bank together to try and resolve this
And where
matter.
are these located? Where are these help things or programs located?
Well, on the 28th floor is when they'll have the initial information gathering with a volunteer attorney there.
Is that where the courtrooms are located?
The mortgage foreclosure courtrooms are on the 28th floor, so it's right
At the Daly
outside
Center.
in the Daly Center, so it's right there.
Right. It's right. It's very convenient. There's nice round tables. There's people sitting there, and I think the courts go to great length to make this whole process, less intimidating. Coming to court's not such a bad thing.
And these people are from where? These people who are helping them, are they lawyers?
Some of them are. A lot of them are housing counselors. Chicago Volunteer Legal Services sends volunteer attorneys that are trained. They come over there, and if they go through this process and they go through the counseling process, then they'll go across the street to the Cook County Administrative Building, 69 West Washington, which is where the mediation will actually take place.
Is that the same day, or is that date set at another time?
It's set at another time.
And is it an agreed upon date by the people as to when they'll come back for it?
Yes.
And then they come back to this mediation session? What goes on just generally about, we have a couple minutes here before we have to take a break. What goes on in this mediation session?
Well, I'll go through it very quickly because I've done it a number of times. First of all, there's usually a representative, an attorney who's a volunteer, not being paid, who represents the defendant. And then Mitch or someone from his office would be there on behalf of the lender. The lender is sometimes they're present in person and always on telephone. Sometimes they speak Spanish or whatever language is necessary. We have interpreters. And the concept is that the lender and the defendant get to go through the mediation process to see if they can get their loan modified, if
And
they
is this,
can.
is this at any cost to anybody?
No.
To the litigant?
Nope.
And if this mediation process is successful, what transpires?
The case is ultimately dismissed on the post-mediation date, which is approximately 12 weeks after the case would have been kind of diverted over to the mediation calendar.
And from the bank standpoint, what happens to the, when you say loan modification, what exactly does that mean?
Well, there would be a change in terms of how much the monthly payment would be. And I want to stress that it's very important for the borrower to have counsel during this process, because there may be certain rights pursuant to that loan modification. They may waive certain rights in the future. So it's very important that they're represented and they understand fully of their obligation. The terms are very flexible. It could be a change in interest rate. It could be a longer term to pay the loan back.
But those terms change have to be reasonable and doable. And I think that's where Mitch and I really see eye to eye on it. A solution, you know, that can't be implemented isn't a good solution. So we go back to what we discussed about you have to be very straightforward if you're a debtor. You know, don't enhance your figures, don't depreciate your figures. You know, put down what you can do.
Okay, you know, we're going to take a little break here. This is the Illinois law sponsored by the Illinois State Bar Association. We're talking about mortgage foreclosures, the litigation process. I'm Sam Kavathis, your host, and we'll be right back with more of the show.
Bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never! Mister!
Over and over,
Time I come home! It's our Leave me alone! Shut up! Out!
time and again,
No! Drive me nuts!
Shut up! You're the dumbest.
generation after generation.
I hate you. I hate you too.
Isn't it time we stop the cycle? Now.
I hate you. I hate you.
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathis, and I'm your host for tonight's show. And we've been talking about mortgage foreclosures, the litigation process, with my guests, the Honorable Judge Margaret Brennan, Steve Bashaw, and Mitch Lieberman. And I think we left off with the mediation process, and we talked about that. But let's say the mediation process doesn't work. What happens then?
Well, if the mediation process does not work, then the burden is really on the plaintiff, the lender. Usually, if the borrower has an attorney or pro se, a motion will be filed. Hopefully at that time, if the borrower had an attorney, there may have been an appearance or an answer. If so, a lender will bring a motion for either default judgment or summary judgment. The process, and we have to be clear about it because the consumer and borrower, they must really understand what they're up against. If a default judgment is brought before the court and judgment is entered, they have a finite period of time to try to pay back what is owed. A minimum 3 months from the date of judgment. It could be 7 months from the date they were served. Service would be when someone came to their house and gave them a summons. At that point in time, they have a period of redemption. Once the redemption expires, a borrower really has very little option. So it's very important that they understand their rights. Again, very important that they have an attorney.
Does the court have any, leeway in that situation when the redemption period ends, or is that by law certain deadlines?
By law, when the redemption period is over, it cannot be extended.
Okay. And Steve, when they come to when that happens and the mediation doesn't work, what kind of things do you do when you're representing the borrowers?
You know, it's interesting, Sam. A lot of times when the mediation doesn't work, the light goes on. I mean, sometimes I see it happen more often than not that people see that the mediation didn't work for a reason, that the house just is underwater, that there really is no utility to it, and it's not as difficult. We don't go back to court sometimes pulling teeth, but at that point, when Mitch brings the motion for summary judgment, my clients get their due process and their accounting. And, that's all the system really can promise us, and that's what we're looking for. And so that's the way it goes.
And let's say judgment is entered. What happens, Judge, after the judgment is entered?
Well, then the plaintiff would also, at the time judgment gets entered, normally gets the appointment of a judicial sales officer, and then they start the process to take the property to sale.
And let's talk about that process.
Okay. Once the judgment is entered and a special selling officer is appointed, there are certain publication periods. A lender must publish in certain newspapers of the sale. The sale cannot take place until after the redemption period.
And how long is that from the time of judgment?
It could be 3 months or 7 months from the date of service, whatever's longer.
Whichever's longer.
But normally it would be 3 months from the date of judgment.
For possession?
Well, no.
Or is that no?
It would be 3 months to schedule a sale.
So that means you have at least 3 months to even extra time to really try and get something together or figure out where you're going to go.
And that's what's important to a defendant, Sam, because now, this process, which is challenging, difficult, has also been nebulous. Now the judgment is entered. We know 90 days from now the redemption period expires. As soon as the next day a sale could be held, then it comes back before the judge to confirm. Then we have 30 days to vacate, or we could be evicted. But you have certainty, and people can deal with it when they have certainty.
So let's talk past the 90 days now. Now the 90 days is up. What's the next step?
Well, it'll be a judicial sale, which is open to the public. Once the sale takes place, a lender will bid, and it's open to the public. Third parties can come in and bid
Can
at
the
sale.
person who is losing the property bid at that?
Well, they could, but I don't think it could hardly happen because you have to have cash.
Okay.
Right.
You have to have at least 10% down in the balance in 24 hours. So if you were going to be in a position, and I've had that happen, where I could bid at sale and I was a defendant, I'd go and I'd redeem. Because why do I want to get involved in that whole sale process?
Now, under certain circumstances, if the plaintiff's the successful bidder and they bid less than the judgment amount, a borrower does have a special right to redeem for 30 days. It's complicated. It's very rare. But what would happen is after the sale, the plaintiff would then notice up a motion for approval of the sale.
So the case goes back before the judge.
Correct.
Right.
And the sale itself can take from anywhere from how long? What's that next process?
Well, the next process would be anywhere from 1 day after the redemption date to 6 or 7 days, depending on the selling officer's schedule.
But it usually is within 30 days the sale takes place?
Of the redemption date, yes.
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 Okay.
And then it goes back before the court. Now, the borrower has certain rights. They can object to the sale. The statute allows certain specific reasons to object to the sale. But if an order approving the sale is entered, that is the final and appealable order in the judicial foreclosure. And by statute, the borrower has 30 days of possession.
And typically, Judge, when somebody comes before you at that point in time after the sale is, what's it called, confirmation?
Yes.
Once the sale is confirmed, what is taken into consideration for the time they actually have to get out of the house, or who gets them out?
Oftentimes the borrower is not looking to object to the sale. They're really looking for additional time, and they may have factors such as small children in the house, school-aged children. It may be getting close to a semester break or end of the school year, and they'd like to just extend out the period of time to make a smoother transition for the children. There could be an ill family member that because of various reasons it would be hard to transport or get suitable housing, and that is where I would take those factors into consideration, perhaps extend out the period of possession for the borrower. And additionally, I think it's important for everyone to understand that until an order states that you are to vacate the property by a specific date or a specific 30 days after the entry of an order, the borrower has possession of that property. So just getting served with the summons isn't time to pack your boxes and plan on moving.
Question, during that whole time period that this is going on, can they still be selling their house or try to sell it or things like that?
Absolutely. The borrower is still in control and
Has
is the
rights.
owner of that house until order approving.
Getting back, Judge, so that the court does have some leeway to determine the time period. The minimum is 30 days, is that what we said?
Correct.
That,
Yes.
that for possession after the confirmation, and sometimes the court can extend it out depending on the situations.
Correct.
Okay.
Let me factor that in.
Is there a time period that, you know, the end time period that you can't go out further than a certain period of time, or is it all depends on the situation?
It depends on the situation. I think another thing, though, certainly you have to be fair to both sides. The lender, throughout this entire process, has also probably gone without receiving any payments as to the note as well.
What do you tell your clients, Steve, at that point
Well,
in
that's
time?
interesting because sometimes we can get a little bit of leeway, but it's not going to be a lot. So the best thing for a homeowner, a mortgagor to do at that point, quite honestly, is to work with the plaintiff. You don't want to be forcibly evicted. It's just,
And what does that actually mean? I mean, when we're talking about an eviction process, what actually happens? Let's say the 30 days, or the judge gives you 60 days, let's say. On that 60th day, what can happen?
Well, in Cook County, the sheriff comes out and he actually forcibly places the people's furnishings out on the stairs and outside in the street, and you know, the representative for the plaintiff padlocks the building. Now, there's a lot of things that happen in between there. One of them, for instance, is many times I counsel my clients to talk to the lender's representative. They have a program, it's on the street, they call it Cash for Keys.
Okay, what is that?
Well, the lender will actually, to avoid the cost, because it's expensive to evict somebody, will offer moving expenses to a borrower. And
So that
if they
assist them, because a lot
voluntarily-
of people say, well, how do I, I'm going to move? And sometimes the lender will make that process in the system and give them a certain amount for where they have to go, what they have to move to.
Yes.
So that's an alternative for them to help them get out of the situation and give them some money, especially a lot of people don't have any money at that time, they're not working. Or
Well,
things like that.
actually, you know, if people are in the process and they're doing that education, here's what they know. It's now almost a year, and during that year that the foreclosure has been on, and maybe 3 months before then, they should have been putting their money aside.
Okay.
So, you know, they should be able to exit, right, unless they have some catastrophe like medical expenses or things like that. And that's what most of my clients do. Most of them have, you know, put their nest egg aside. They know with certainty when they have to get out, and they do it.
Okay. We hear that thing short sale at all. I mean, is that part of the thing that goes on at that point in time, or is that past that? Or
Well, a short sale is really an alternative to the foreclosure process.
Okay.
It's difficult. It's prior to confirmation of the sale, and there's so many different variables. Can a consumer, a borrower, find a buyer for the real estate? Then they have to go to the lender and see if they'll take less money than is owed. There's so many factors.
So you hear that stuff, oh, let's just give the property back for a short sale. It isn't what everybody hears all the time. It's not that easy process that you're talking about.
It is difficult with a lot of variables.
Just finding a buyer who's flexible, turning over possession is extraordinary.
So
Yeah.
once that's done and they've made the deal for the possession, then is title given over to the property once they're out, or is title given earlier?
Actually, title is transferred at order approving sale. A judicial deed is issued to the lender or an agent or an entity of the lender. Sometimes the lender will wait 30 days before they record it based on the appellate rights and things of that nature.
Okay. Well, this is a very fascinating topic. It's a lot of people are going through this. I think the Tonight Show has given everybody a little glimpse of what goes on. It was very educational. I'd like to thank my guests, the Honorable Judge Brennan, Steve Bashaw, and Mitch Lieberman for being with us here on Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathis. I've been your host for tonight's show on mortgage foreclosures. And again, There are some numbers that have been up during the show that you can contact for assistance for the different foundations. Judge, again, what are the different foundations that you can go to or call for assistance?
Well, you can go through the Cook County Mortgage Foreclosure Mediation Program or Chicago Volunteer Legal Services would be the two numbers to pursue.
All right. And they also have a help desk. Thanks very much.